Hello, I know I'm a little late. I'm sorry. This is Mentor Lawyer. I know Ladybug has been sharing my favorite trial with you guys, and I'm glad you're here to watch a little more of it. I'm going to leave most of it for her to continue sharing with you guys next week, but I'll definitely go ahead and put a little bit of it for you guys to continue watching today with me. Not all of, not several hours, but maybe about an hour or so of the trial. So let me go ahead and find it. I call it the best trial ever. Of course, the best part of the trial is that there is nobody who died. It's not a murder trial. It is an attempted murder trial where the victim did well and recovered. Of course, traumatized by the incident, but doing well. So let me go ahead and find it. Oh, Dexter. Where's Dexter? Oh, maybe it's on Deep Dive. All right. Anyway, so I hope you guys are doing well. Hello, Helen. Nice to see you. Give me a second because I need to find the video. I realized that I was late, and so I didn't get set up. So let me go ahead and find it. Best trial ever. Here we go. Show all 7. All right. So this is number 5. Here we go. Okay, we got closing arguments. Oh, this is going to be fun. So let me go ahead and start. And we'll join you guys there. Hi. Here we go. Share screen. Best trial ever. Closing arguments. Let me know if the sound is good and all that. And here we go.
Order the court all rise. Sir, court for Gadsden County, Judge
Here.
Marsh, now from back.
Hey, good morning, everyone. Please be seated. Good morning. All right, we're back this morning in case number 2021-388 CFA State versus Dexter Lawson. You should see on your desks I put out final jury instructions and verdict form. During the evening, I did make a couple of changes that we had not discussed, so I just wanted to put those on the record. The first is on page 1. I changed it from grand theft of a motor vehicle just to theft as we have captioned it. I'll note that previously where we had the reclassified language, I just made that interrogatories to separate the charges and lesser includeds themselves from the interrogatories.
Yes, sir.
On count 3 theft, page 13, I made it an 2A or B, commensurate with the statutory provisions.
Yes, sir.
And then the pro se defendant, I moved it. It's the instruction's still there, but it was in the middle of talking about witnesses, and I didn't want it to be confusing about the defendant and being a witness. I go into all the witness stuff first, then I put it right before rules for deliberation, or right before rules for deliberation, because that's a factor they are not to consider, whether, positively or negatively that he represented himself. And I think those are the only changes made last night. So with that, any objections, additions, subtractions, etc., from the instructions and verdict form?
No, Your Honor, I've reviewed both of them this morning. I'm in agreement with what the court and what we discussed yesterday in open court. I think the editing has been consistent with each of the rulings and the agreements of the parties yesterday.
All right, Mr. Lawson.
No, sir.
All right. As far as closings go, gentlemen, do we want to have the podium up? I do notice the TV's ready as in case the parties might be playing some videos, showing some pictures. I understand that. I wasn't sure if the parties wanted to also use the podium. I just wanted to talk about that.
I'm happy to set up the podium. A couple things. Yes, sir, I was planning on paying that. As I did during the trial, if Mr. Lawson wants any of I have that wired. He need only told me what he wants played, and I'll be happy to publish it on demand. I can pretty much, as I have throughout the trial, run it from my desk without interrupting him. So my preference is to have the podium. I understand it may shield a little bit from there, but once again, as long as the court, I can move, or I can kind of slide towards the court reporter if I'm using that, or move towards Mr. Lawson, just so they can have a clear eye shot. But once again, that's my preference, is to be able to use the podium and put it where it was through voir dire, which is basically halfway between counsel tables. So it's halfway between Mr. Lawson and I. We're not invading the province of the jury. We're not, but we can both have that for our use.
Mr. Lawson, does that work for you? Do you want the podium or not? Again, I give the parties fairly broad range during closing argument, but what I don't want them doing is basically going in front of where that microphone is on Mr. Campbell's desk. I don't want anybody closer to the jury than that. But as far as you're right there in that general well area, I mean, I'm okay if you need to move around a little bit. And again, Mr. Campbell has indicated if you want any of the pictures or the videos, things that were admitted into evidence, not things that aren't in evidence, but anything that was admitted into evidence, if you want it to be played, you just let him know and he'll play it. So that's how we'll run that. Any other requests or any questions regarding the closing arguments, sir?
As long as I can be able to play what was put in the evidence, I'm good with that.
You do or do not want?
I'm on that.
Okay. Well, if you'll just let Mr. Campbell know, we're actually going to take a break here shortly because the jury's not here. I'm going to let you guys get the courtroom set up for closing argument. And if you know now, that's fine. If you don't know because you're waiting to hear his closing, that's fine too. But if you know in advance which videos you might want played or pictures you might want, if you'll let the state know during this break, they can get it queued up and have it ready to go. But I'm not sure, Mr. Campbell, how long your closing is going to be, and I'm not holding to it. But we may want to take a break after Mr. Campbell's closing anyway. That'll give you time to get that set up with him, because I'll tell you, you guys have seen it. We've got 19 pages for me to read them before Mr. Campbell even gets to make his closing argument. So we might take a break. We'll see how we are on time. And then Mr. Lawson, you'll be able to do your closing argument. And then Mr. Campbell will get a rebuttal pursuant to the rules of criminal procedure. So what other questions do we have, or anything we need to address before we break to get ready for the jury?
Your Honor, the only thing I have, and it's really a housekeeping issue, as I announced the other day, I have filed a notice of intent to seek enhanced penalty under the Prison Release the Reoffender. I have a copy for the defendant. I'm handing it on the record to him at this point. Should he be found guilty of an eligible felony, he does have, obviously, a criminal history. Should the court decide they want to go straight to sentencing, he's not entitled to a PSI, but I just wanted to make sure that I gave him that on the record beforehand. And I'll be prepared for however the court wants to take that next step. The victim and her family is present in the courtroom, so I would want to have an opportunity to kind of discuss that. She would have a right to be heard. Mr. McNeil, I've spoken to from McNeil, is the victim of count 3. He's less concerned about being here. There's some restitution outstanding for the damage to the truck, but candidly, counts 1 and 2 are probably going to be the driving factors on sentencing.
Well, I don't want to put the cart before the horse, obviously, but one other thing is, number one, I don't know what this jury is going to decide. And number two, Mr. Lawson, if there is any conviction in this case on any charge, one of the first things I'm going to do after we get the jury out of here and on their way is we're going to have another talk about your rights to counsel, because at that point, if there is a conviction, I will indicate that you do have the right for counsel to represent you in sentencing. And so we'll go through that. And if you elect counsel, then we'll have to get counsel involved. So again, I appreciate the heads up, folks, and we'll have to cross that bridge when we get there. We'll have to let this jury make a decision as to what the facts are in this case. So
Understood, sir. Thank you.
I also want to ask you, Judge. Okay, you said when I did open argument or everything, I wasn't gonna be able to say what I wanted to say. Then it was proper to say it for the closed argument, right? So only thing I want to do is make sure that I'm able to say what I want to say with respect for the court. And the thing that I'm gonna be saying is gonna be consistent of what's on social media, the news and everything, because for one, my situation is open to the news. So therefore, like, if I want to use anybody else in reference to comparing to what the state that have been said about me, I was asking you, am I able to do that?
all right, Mr. Campbell.
Your Honor, the court, and candidly, I did not make particular objections during opening. Mr. Lawson is indicating he wants to go into similar matters concerning other cases and controversies on the national level. Things that were brought up previously were abortion, President Trump, Breonna Taylor, some of the things that I remember, none of which are relevant to this case. And I would suggest their only purpose is to inflame the jury and to create issues that should not be germane. So I would move in limine that the defendant keep his arguments. I mean, obviously, if he can link it back, examples of, and as we often, analogies or metaphors or other things like that. But as much as he is making a social activist argument or a commentary on the American system or the jurisprudence in general, I think it certainly an opening, and he got in a little bit Vaudire, a little far afield, and I think it would be inappropriate for closing. So I don't want to do a bunch of objections and cause him. So since he's raised it now, I will kind of make a standing objection concerning the argument is on this case and not on whether or not various law enforcement officers may have been inappropriate in their use of force against other defendants. Once again, whether other politicians in America have appropriately done things, whether what happened in Washington, D.C. on January 6th, none of that is germane to the issues at bar. And as such, the state would object to trying to inflame the jury or really frustrate the jury by injecting things that are not before us.
Well, let me ask you this, Mr. Lawson, because I understand your concern for wanting to argue your case, but in opening, you brought up Breonna Taylor, Kyle Rittenhouse, George Zimmerman, Donald Trump, January 6th, abortion, and a number of other things. How are those in any way, shape, or form relevant to your case and arguing whether the evidence in this case has proven beyond a reasonable doubt that you are guilty of any offense that's charged?
I got it. Okay, I'm going to give you a prime example. So it said like, okay, the country of the state will not allow anyone to be sanctioned on a conviction on speculation, intuition, or hunch, right? So throughout the whole procedure with the evidence that the state is presenting, it's just circumstantial evidence. It's speculation. They're using intuition and they also use the hunches. Okay, the past is real. The past is facts. Okay, so therefore it's relevant to what's going on right now because for one, they got the burden of proving beyond a reasonable doubt every element, but it's up to their discretion if it's facts or not. Okay, the past is all that real. The things that done happened with in the past, those are facts. Okay, why is it not relevant to what's going on with me? Being that whatever I say on the witness stand is considered evidence, but whatever I say outside of the witness stand is not evidence. Okay, but it's in my defense to say that because it have been a situation that can transpire where you got more than enough evidence. Like with Breonna Taylor's situation, that's relevant to me directly because guess what? Okay, they got the video, but the video is not showing I actually shot 6 times. That's what the state said. The state said they were going.
Well, hold on, sir. Let me caution you. Be careful what you ask for. You may get it. In the example of Breonna Taylor, you have an African-American woman killed, and people are saying there was no justice because an African-American woman was killed. In this case, this isn't a white officer that is accused of violence against an African-American person with an excessive use of force. You're being charged with violence against an African-American female law enforcement officer. So again, be careful what you ask for. You may get it. If I let you go with those arguments, Mr. Campbell may bring up that very fact.
I mean, that's what I'm asking for that, sir. I mean, that's what I'm asking for. I mean, it done already done got me this far, so we might as well keep continuing. So that's what I'm asking you, Judge, like, okay, in my closing argument, am I able to, because it's relevant, because just because she's a black woman, she's still police, and the police has been getting favoritism in all types of situations. So, I mean, that's all I'm asking.
Well, here's the thing. The laws of the state of Florida and the case law do not allow bringing in politics and inflammatory. There is no evidence before this jury about Breonna Taylor's case. So you say everybody knows it, but you know what? There are wide swaths of this country that people have differing views on what happened there. We didn't sit through a trial for Breonna Taylor. We didn't sit through the Kyle Rittenhouse trial in this courtroom. So what this jury may or may not know about those situations, it's all from social media, news, and that is not something they are to consider. Remember what we told them at the beginning, what I told them is they are to only consider what's evidence from this courtroom. They're going to learn everything they need to about this case in this courtroom. They didn't learn anything about Breonna Taylor. They didn't learn anything about Kyle Rittenhouse. They didn't learn anything about George Zimmerman. They didn't learn anything about George Floyd. None of those. And despite the fact that they may be tragedies, they are not relevant to this case
So-
in a court of law.
So-
It may in a court of public opinion, but that's why we're in a courtroom. We're not in the court of public opinion.
But my defense though, Your Honor, because for one, it's like it is relevant. That's where we got a different opinions at, because it's relevant because state of Florida is united with every other state. So all y'all is one body. So and the state is against me, the defendant. So when you say it's relevant, it's not irrelevant. It's relevant to what happened with my situation, because for one, I'm on national news, therefore it went political.
Well, once again, sir, these jurors, we asked them in voir dire about whether they knew anything about any news. And that's why we asked that question. And if they had heard about it and they had formed opinions and all that, we could have gotten rid of them. So this is not in front of the news on them. They're not supposed to know. I've told them not to watch the news. I've told them not to be plugged in. You're the one injecting the news into it if that's what you bring up. So I understand in your mind it is relevant, and it may be relevant in a colloquial sense, but in a legal sense, it is not legally relevant. And so I am not going to let you inject politics. I'm not going to let you, unless you have a proper argument that ties it, and you have not expressed that yet. So I'm going to grant the state's motion in limine. You're not to be talking about Breonna Taylor, Kyle Rittenhouse, Donald Trump, George Zimmerman, George Floyd. You're not to talk about any of that. You're not to be talking about national media. You're going to talk about the facts of this case, the evidence in this case, the law is instructed by this court, and you can use proper non-political analogies. Let me give you an example. There is one of my favorite, it's actually a legal instruction in the military about circumstantial evidence. And it says something like this, is that circumstantial evidence and direct evidence differ in the following way. Direct evidence is you walk outside and you see it rain. That's direct evidence of the rain. Somebody testifies, I saw it rain. Circumstantial evidence is you get up in the morning, you walk outside, and everything is wet. Your rain gauge has water in it. And the night before, while you were sleeping, you think the rumble of thunder. That's circumstantial evidence. So by giving the analogy of the rain, that's something you can do to argue, ladies and gentlemen of the jury, there's circumstantial evidence of something because, you know what, because of this, that's like the rain. Nobody actually saw it raining that night, but you're sure beyond a reasonable doubt it did rain because it's wet outside, because the thunder was rumbling, because there's water in my rain gauge, and my dog was shaking under the bed. So that I'm going to let you argue by analogy, but I'm not going to let you argue politics, national media. I'm not going to let you the social justice events. I'm not going to let you argue those.
So let me get it right. So state can say anything that can be considered evidence, but I'm limited to what that's a violation of my freedom of speech. Like I should be able to argue whatever I want to argue. I mean, I got the freedom of speech. So you first you eliminated me. You limited me in every way throughout the whole trial process. Yeah? That's unfair all around the board. And then you tell me what I can't argue when they get further grab on all the evidence from the law enforcement and everything. Then you tell me that, okay, I can say this, but it's not considered evidence. That's unfair all around the board, Judge. And you is not being fair right now at all.
All right. Well, I'm sorry that you feel that way, sir. I follow the law. This is again, an attorney might have been able to explain that to you, but Mr. Campbell isn't allowed to argue just anything he wants. If he starts arguing about, people's disregard for this law enforcement, he can talk about disregard at this case, but he can't talk about outside of this. He can't He can't talk about, let me talk to you about violence against African-American women at the hands of men and bring up all kinds of examples out in society of violence against African-American women by men. I'm not going to let him argue that. So I'm going to restrain everyone from injecting politics and inflaming the passions of the jury. It's not authorized under Florida law. The freedom of speech is not totally and completely unabridged. It can be limited in certain circumstances, some of which is in a court of law. If you want to, when you eventually, if you were to walk out into the streets and be freed, after this case, if this jury finds you not guilty and you want to go out there, by all means, there's freedom of speech. But in this courtroom, you have to abide by the laws of the state of Florida, the rules of criminal procedure, and the case law in Florida that explains that. So
like with the Delgado versus State, when this defendant hit the car several times, I got hit the car several times with a police. Hit the police car several times. Okay, that none of those, I can't use no reference to what the state is presenting. I can't compare it to nothing. That's what you're basically saying.
What's your comparison? Please go forward with this argument. Make this argument to me and let me see. Maybe you can.
One hit. It was one hit, one impact. That's all I did. Okay, this other dude ran to the police car several times, and they saying if he would have hit one time and that was it would have been an argument. Okay, now in my situation, it's one time. It was just one impact, one hit. All right. Okay, and if they said that in that case, then that's pertaining to my case. Am I right or wrong?
I don't understand what case. What did they say in some?
Delgado hit the truck, the police car. He hit the police car head on. Came back and hit it again. Hit it 3 times. Okay, in my situation, it was only one time I hit the police car. But
what was the result of that case?
They found him guilty because the argument was if it would have been one impact, then it would have been either attempted to flee or attempted murder. In that situation.
And who says this? A court? What?
This is a case law. This is a case law that happened before.
What case are you talking about?
Delgado versus State.
All right, do you have a citation on that?
I ain't got it off the top of my head.
Are you saying the court, as a matter of law, said that couldn't be attempted murder?
Right.
Do you know what court is this? Florida Supreme Court? Is this First District Court of Appeals? I'm the only Delgado versus State I find quickly is 776 Southern 2nd 233 from the Florida Supreme Court in 2000, but that doesn't seem to be applicable. So
Can't recall off the top of my head. I got it wrote down. I ain't got it with me.
Your Honor, I found a couple when went to kidnapping that they reversed because they didn't prove that the defendant knew there was a child in the car. I've got death penalty, Delgado 162, Southern 3rd, 971, which seems to be dealing with capital sentencing. Please.
yeah, I'm seeing several different Delgado these states, but I haven't seen any that are applicable. Well, here's the thing, sir. I'm going to let you argue that, hey, it's only one impact. This could be a fleeing. I'll let you argue that, but I'm not going to let you say, but this is what happened in some other case that they don't have the facts and circumstances under. So if you want to argue, by all means, that's a perfectly appropriate argument to say, listen, there was one impact. They haven't shown beyond a reasonable doubt. This wasn't me just trying to drive away or whomever. Maybe you're not even conceding it's you. That's up to you. But if you're saying they haven't shown that the driver of that vehicle wasn't just trying to get away, and you know, they haven't shown that that was an intent to cause the death. That doesn't show a premeditation. They can't show the operation of the mind. You can absolutely argue that. What you can't do is say the government didn't prosecute in a certain case, because that's a discretionary function of an elected official. Well, Mr. Campbell is the elected official, and he has used his discretion to charge this case. And that is a power granted to him under the Constitution and by the voters of the Second Judicial Circuit, that he can charge. There are other cases he can decide not to charge. And ultimately, he is accountable to the voters of the state of Florida in his discretion of when he chooses to charge and not charge.
Okay, I argue the democracy. Can I argue?
What and what's that, sir?
Just defining what democracy is. That's all.
Oh. Well, if you want to talk about democracy and that the people get to govern, you get to say they are the people that ultimately decide the facts. You can do that. That's perfectly appropriate to say this is part of democracy, is that we have jurors. Mr. Campbell doesn't get to decide whether you're guilty or not guilty. Judge Marsh doesn't get to decide whether you're guilty or not guilty. None of us get to decide. The 6 men and women that are ultimately on this jury, they decide the facts. If you want to talk about that, that's fine. That's absolutely fine, and that's appropriate. That is the heart of our system of government, is that the people will speak. They are the judges of the facts in this case. All right. Is there anything else we need to discuss?
No, sir. State's ready. Otherwise,
how long do we need to take to get set up?
I'm ready. 30 seconds.
All right. Well, why don't we take about 5 minutes? I'm going to step off the bench. That way we can get the podium moved around, and then we'll get everybody back in. All right. We'll be in recess for about 5 minutes. That'll give us time to get the camera set up. So.
Thank you.
All right, everyone, please be seated. All right, are we ready to bring in the jury?
State's ready, Your Honor.
Mr. Lawson, you ready?
Yes, sir.
All right, and just for the bailiff's benefit, when I've got the jury instructions, so we'll go ahead and very soon after and start passing those out. These are the jury instructions. No, I'll say basically right after they come back in, I'll talk to them for a brief moment, and then I'll say both the state and the defense have now rested their cases. Then we'll pass it. All right, let's go ahead and call them the jury.
All right, so the jury.
All right, ladies and gentlemen of the jury, please be seated. Everyone else may be seated. Good morning, ladies and gentlemen, and welcome back. I hope everyone had a restful night of sleep. So the plan this morning is that I'll be giving you the instructions on the law. The parties will then make their closing arguments. I'll give you some final instructions. I'll discharge our two alternates, and then the six of you that are on the jury will head back and begin your deliberations. So with that, ladies and gentlemen, both the state and the defense have now rested their cases. Jurors, you have now heard and seen all the evidence that will be presented. Now you are being handed jury instructions. Please look at only the first page and turn the page only when we get to that portion. I thank you for your attention during this trial. I now ask you to give the same careful attention to the law that I am about to deliver to you, which you must apply to the facts as you find them from the evidence. Please follow along with me as I read the instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Dexter Lawson, the defendant in this case, has been accused of the crimes of attempted first-degree murder, 2 counts, theft, and tampering with physical evidence. Dexter Lawson is accused of attempted first-degree murder in counts 1 and 2. Attempted first-degree murder includes the lesser crimes of attempted second-degree and attempted manslaughter by act, all of which are forms of attempted homicide and all of which are unlawful. However, an attempted homicide that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find that there was an attempted homicide of CH by Dexter Lawson, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. An attempted homicide is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the attempted homicide. An attempted homicide is excusable and therefore lawful under any one of the 3 following circumstances. 1, when the attempted homicide is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the attempted homicide occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the attempted homicide is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the attempted killing is not done in a cruel and unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Dexter Lawson may be found guilty of attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act. To prove the crime of attempted first-degree premeditated murder in count 1, attempted first-degree murder with a vehicle, the state must prove the following 3 elements beyond a reasonable doubt. 1, Dexter Lawson did some act intended to cause the death of CH that went beyond just thinking or talking about it. 2, Dexter Lawson acted with a premeditated design to kill CH. 3, the act would have resulted in the death of CH except that someone prevented Dexter Lawson from killing CH or he failed to do so. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is committed, let me read that again. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of attempted first-degree murder are attempted second-degree murder, attempted manslaughter by act, aggravated battery, and battery. To prove the crime of attempted second-degree murder, the state must prove the following 2 elements beyond a reasonable doubt. 1, Dexter Lawson intentionally committed an act which would have resulted in the death of CH except that someone prevented Dexter Lawson from killing CH or he failed to do so. 2, the act was imminently dangerous to another and demonstrated a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Attempted manslaughter by act. To prove the crime of attempted manslaughter by act, the the state must prove the following element beyond a reasonable doubt. Dexter Lawson intentionally committed an act which would have resulted in the death of CH, except that someone prevented Dexter Lawson from killing CH, or he failed to do so. However, the defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Every person has a duty to act reasonably and use ordinary care toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of attempted manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act which would have caused death and was not justifiable or excusable attempted homicide, as I have previously instructed you. To prove the crime of aggravated battery, the state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery. 1. Dexter Lawson actually and intentionally touched or struck CH against her will. 2. Dexter Lawson, in committing the battery, used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. For example, in cases where a person intentionally drove into another occupied vehicle, it is for you to determine whether the vehicle that was struck should be considered as a part or as an extension of the person inside that vehicle. This determination may include consideration about whether the person was touched through the force of impact by being jostled or otherwise impacted through the transfer of energy from the collision. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. Dexter Lawson actually and intentionally touched or struck CH against her will. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as part of, or as a part or as an extension of the person. For example, in cases where a person intentionally drove into another occupied vehicle, it is for you to determine whether the vehicle that was struck should be considered as a part or as an extension of the person inside that vehicle. This determination may include consideration about whether the person that was touched through the force of impact being jostled or otherwise impacted through the transfer of energy from the collision. Interrogatories. If you find Dexter Lawson guilty of attempted first-degree murder or attempted second-degree murder, you must also determine if the state has proven beyond a reasonable doubt: 1. CH was a law enforcement officer. 2. Dexter Lawson knew that CH was a law enforcement officer. 3. CH was engaged in the lawful performance of a legal duty. Law enforcement officer means any person who is elected, appointed, or employed full-time by any municipality or the state or any political subdivision thereof, who is vested with authority to bear arms and make arrests, and whose primary responsibility is the prevention and detection of crime or the enforcement of the penal, criminal, traffic, or highway laws of the state. This definition includes all certified supervisory and command personnel whose duties include in whole or in part, the supervision, training, guidance, and management responsibilities of full-time law enforcement officers, part-time law enforcement officers, or auxiliary law enforcement officers, but does not include support personnel employed by the employing agency. If you find that Dexter Lawson committed attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act, and you also find beyond a reasonable doubt that during the commission of the crime, he personally used a weapon, you should find him guilty of attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act with a weapon. A weapon is defined as 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used or intended to be used to inflict bodily harm. If you find that Dexter Lawson committed attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act, but you are not convinced beyond a reasonable doubt that he personally used a weapon, then you should find him guilty only of attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act. Count 2, attempted first-degree murder, this with a firearm. To prove the crime of attempted first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Dexter Lawson did some act intended to cause the death of CH that went beyond just thinking or talking about it. 2, Dexter Lawson acted with a premeditated design to kill CH. 3, the act would have resulted in the death of CH except that someone prevented Dexter Lawson from killing CH or he failed to do so. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crimes indicated in the definition of attempted first-degree murder are attempted second-degree murder, attempted manslaughter by act, aggravated battery, and battery. To prove the crime of attempted second-degree murder, the state must prove the following 2 elements beyond a reasonable doubt. 1, Dexter Lawson intentionally committed an act which would have resulted in the death of CH, except that someone prevented Dexter Lawson from killing CH or he failed to do so. 2, the act was imminently dangerous to another and demonstrated a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of attempted manslaughter by act, the state must prove the following element beyond a reasonable doubt. Dexter Lawson intentionally committed an act which would have resulted in the death of CH, except that someone prevented Dexter Lawson from killing CH, or he failed to do so. However, the defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Every person has a duty to act reasonably and use ordinary care toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of attempted manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act which would have caused death and was not justifiable or excusable attempted homicide, as I have previously instructed you. To prove the crime of aggravated battery, the state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery. 1. Dexter Lawson, A, actually and intentionally touched or struck CH against her will, or B, intentionally caused bodily harm to CH. 2. Dexter Lawson, in committing the battery, used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object is not designed to inflict bodily harm. Let me say that again. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. For example, in cases where a person intentionally drove into another occupied vehicle, it is for you to determine whether the vehicle that was struck should be considered as a part or as an extension of the person inside that vehicle. This determination may include consideration about whether the person was touched through the force of impact by being jostled or otherwise impacted through the transfer of energy from the collision. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. 1. Dexter Lawson actually and intentionally touched or struck CH against her will, or 2. Dexter Lawson intentionally caused bodily harm to CH. A battery may be found as a result of the intentional touching or intentional striking of someone other than the actual, of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. For example, in cases where a person intentionally drove into another occupied vehicle, it is for you to determine whether the vehicle that was struck should be considered as a part of or an extension of the person inside that vehicle. This determination may include consideration about whether the person was touched through the force of impact by being jostled or otherwise impacted through the transfer of energy from the collision. Interrogatories. If you find Dexter Lawson guilty of attempted first-degree murder or attempted second-degree murder, you must also determine if the state has proven beyond a reasonable doubt: 1. CH was a law enforcement officer. 2. Dexter Lawson knew that CH was a law enforcement officer. 3. CH was engaged in the lawful performance of a legal duty. Law enforcement officer means any person who is elected, appointed, or employed full-time by any municipality or the state, or any political subdivision thereof, who is vested with authority to bear arms and make arrests, and whose primary responsibility is the prevention and detection of crime or the enforcement of the penal, criminal, traffic, or highway laws of the state. This definition includes all certified supervisory and command personnel whose duties include, in whole or in part, the supervision, training, guidance, and management responsibilities of full-time law enforcement officers, part-time law enforcement officers, or auxiliary law enforcement officers, but does not include support personnel employed by the employing agency. If you find that Dexter Lawson committed attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act, and you also find beyond a reasonable doubt that during the commission of the crime, he personally used a firearm, you should find him guilty of attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act with a firearm. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. If you find that Dexter Lawson committed attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act, but you are not convinced beyond a reasonable doubt that he personally used a firearm, then you should find him guilty only of attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act. If you find that Dexter Lawson committed attempted first-degree murder, attempted second-degree murder, or aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery with discharge of a firearm. If you find that Dexter Lawson committed attempted first-degree murder, attempted second-degree murder, or aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm to CH, you should find the defendant guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery with discharge of a firearm causing great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Dexter Lawson committed attempted first-degree murder, attempted second-degree murder, or aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. This frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means that the defendant A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. To prove the crime of theft, the state must prove the following two elements beyond a reasonable doubt. 1, Dexter Lawson knowingly and unlawfully obtained, used, or endeavored to obtain or to use the property of Keith McNeil Plumbing. 2, he did so with intent to either temporarily or permanently, A, deprive Keith McNeil Plumbing of their right to the property or any benefit from it, or B, appropriate the property of Keith McNeil Plumbing to their own use or to the use of any person not entitled to it. If you find the defendant guilty of theft, you must also determine if the state has proved beyond a reasonable doubt whether the stolen property was a motor vehicle. Motor vehicle means any automobile, motorcycle, truck, trailer, semi-trailer, truck, tractor, and semi-trailer combination, or any other vehicle operated on the roads of this state used to transport persons or property and propelled by power other than muscular power, but the term does not include traction engines, road rollers, motorized scooters, micro mobility devices, personal delivery vehicles, mobile carriers, special mobile equipment, vehicles that run only upon a track, bicycles, electric bicycles, swamp buggies, or mopeds. Obtains or uses means any manner of A, taking or exercising control over property, B, making any unauthorized use, disposition, or transfer of property, C, obtaining property by fraud, willful misrepresentation of a future act, or false promise, D, conduct previously known as stealing, larceny, purloining, abstracting, embezzlement, misapplication, misappropriation, conversion, or obtaining money or property by false pretenses, fraud, deception, or other conduct similar in nature. Endeavor means to attempt or try. Property means anything of value and includes tangible or intangible personal property, including rights, privileges, interests, and claims. Value means the market value of the property at the time and place of the offense, or if that value cannot be satisfactorily ascertained, the cost of replacement of the property within a reasonable time after the offense. Count 4, tampering with physical evidence. To prove the crime of tampering with physical evidence, the state must prove the following two elements beyond a reasonable doubt. 1, Dexter Lawson knew that a criminal trial, proceeding, or investigation by a duly constituted law enforcement agency of this state was pending or about to be instituted. 2, Dexter Lawson altered, destroyed, concealed, or removed any firearm and or clothing with the purpose to impair its verity or availability in the investigation or proceeding. The defendant has entered a plea of not guilty. This means that you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and that the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Now, it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, Did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions, including the defendant's acting as his own attorney? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. Now, the fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Now, expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. Now, it is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. Now, you may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Now, the Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Now, a statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Dexter Lawson has the right to be represented by an attorney or to represent himself in this trial, as do all criminal defendants in this country. He has exercised his constitutional right to act as his own attorney. This decision should not affect your consideration of this case. Now, these are some general rules that apply to your deliberation. Correction, let me say that again. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Now, deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Now, you may find the defendant guilty as charged in the information, or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your consideration, the necessary verdict form has been prepared for you. It is as follows. I did not give you all your own copy of the verdict form, so I'll have you look up here. I'm only sending one back with you. So I'm going to hold it up. You'll have this in front of you when you go back there, so I know you can't read it from this distance unless you've got super eyesight. But I'm going to hold it up to show you these, and these will align with the questions that were posed to you in the verdict, in the instructions. So it is as follows. In the Circuit Court of the Second Judicial Circuit in and for Gadsden County, Florida, State of Florida versus Dexter Lawson, verdict. Count 1, attempted first-degree murder vehicle. We, the jury, find as follows as to count 1 of the information. Check only 1. A, the defendant is guilty of attempted first-degree murder. If choice A is checked, proceed to the interrogatories, and you'll see those on the next page. B, the defendant is guilty of the lesser included offense of attempted second-degree murder. If choice B is checked, proceed to the interrogatories. C, the defendant is guilty of the lesser included offense of attempted manslaughter by act. If choice C is checked, proceed to the interrogatories. D, the defendant is guilty of the lesser included offense of aggravated battery. If choice D is checked, proceed to the interrogatories. E, the defendant is guilty of the lesser included offense of battery. F, the defendant is not guilty. Interrogatories, count 1. If you find the defendant, Dexter Lawson, guilty of attempted first-degree murder or attempted second-degree murder, choices A or B above, you must answer the following questions. Has the state proven beyond a reasonable doubt that 1, CH was a law enforcement officer? Yes or no. 2, the defendant knew that CH was a law enforcement officer? Yes or no. And 3, CH was engaged in the lawful performance of a legal duty? Yes or no. Now, if you find the defendant Dexter Lawson guilty of attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act, choices A, B, or C above, you must answer the following question. During the commission of the offense, did Dexter Lawson personally use a weapon? Yes or no. That'll take us to page 3, which is count 2, attempted first-degree murder, firearm. We, the jury, find as follows as to count 2 of the information. Check only 1. A, the defendant is guilty of attempted first-degree murder. If choice A is checked, proceed to the interrogatories. B, the defendant is guilty of the lesser included offense of second-degree murder. If choice B is checked, proceed to the interrogatories. C, the defendant is guilty of lesser included offense of attempted manslaughter by act. If choice C is checked, proceed to the interrogatories. D, the defendant is guilty of the lesser included offense of aggravated battery. If choice D is checked, proceed to the interrogatories. E, the defendant is guilty of the lesser included offense of battery. F, the defendant is not guilty. The interrogatories as to count 2, just mentioned above, are: if you find Dexter Lawson guilty of attempted first-degree murder or attempted second-degree murder, choice A or B above, you must answer the following questions. During the commission of the offense, has the state proven beyond a reasonable doubt that 1, CH was a law enforcement officer, yes or no? 2, the defendant knew that CH was a law enforcement officer, yes or no? 3, CH was engaged in the lawful performance of a duty. 3, CH was engaged in the lawful performance of a legal duty, yes or no? Now, if you find the defendant Dexter Lawson guilty of attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act, choice A, B, or C above, you must answer the following question. During the commission of the offense, did Dexter Lawson personally use a firearm, yes or no? If you find the defendant Dexter Lawson guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery, choice A, B, or D above, you must answer the following question. During the commission of the offense, did the defendant personally discharge a firearm, yes or no? If you find the defendant Dexter Lawson guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery, choice A, B, or D above, you must answer the following question. During the commission of the offense, and as a result of the discharge of the firearm, was great bodily harm caused to CH, yes or no? Now, if you find the defendant Dexter Lawson guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery, choices A, B, or D above, you must answer the following question. During the commission of the offense, did the defendant actually possess a firearm, yes or no? Count 3, theft. We, the jury, find as follows as to count 2. I've made a Scribner's error. That will be count 3 of the information. Check only 1. The defendant is guilty of theft. That's choice A. If choice A is checked, proceed to the interrogatory. Or B, the defendant is not guilty. The interrogatory has to count 3. If you find the defendant Dexter Lawson guilty of theft, choice A above, you must answer the following question. Has the state proven beyond a reasonable doubt the property taken was a motor vehicle, yes or no? In count 4, tampering with physical evidence. We, the jury, find as follows as to count 4 of the information. Check only 1. A, the defendant is guilty of tampering with physical evidence. B, the defendant is not guilty. So say we all. On August, you'll put the date you render your verdict, and that verdict form will be signed by the foreperson. Now, ladies and gentlemen, both the state and the defendant have now rested their cases. The attorneys, including Mr. Lawson acting as his own attorney, will present their final arguments. Please remember, but what they say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. With that, state, you may argue.
Thank you, Honor. May it please court. Counsel. On November 16, 2021, in the middle of the day, defendant Dexter Lawson started making some choices. He made some decisions, and those decisions drive the decisions you will make in the coming hour. I will first want to thank you for the attention that you've brought. This has been a long 3 days of listening to subjects that we just as well not. There's a reason why they're crimes, and because the reason that we criminalize conduct is because it's so abhorrent. It's something that we don't want to know. But as we talked about in jury selection, our very democracy depends upon the people, the members of our community coming forward and making important decisions. And that is what the state asks you to do. The state suggests that the evidence here has been compelling and direct. And now that you have heard the law, it all makes sense. I think probably the best, what I'd like to do is go over the evidence as to each, and I want to start basically where this started, which was really with the theft. It started because two plumbers from McNeil walked into a fast food restaurant to use the bathroom to eat their lunch. And the defendant made a decision to steal the truck. That's in evidence. You can watch him walk out of the restaurant wearing the gaiter around his face, the sunglasses, the hoodie, the brown jacket, the red checked shirt. He decided, starting in Leon County, to go and take something that was not his and that he was not entitled to have. McNeil gives those trucks to each of their workers. They're out there doing renovation on a bathroom. Because they're doing plumbing, they need to use the bathroom and rush over. Were they naive or making a mistake leaving the keys in the ignition? Absolutely. Does that excuse and make it okay to steal? Absolutely not. Now, the way the law requires us to do it is we want to be very explicit and detailed on what we find. So, when you all look at your instructions in your verdict form, that's why I think probably the easiest one is to start with count 3. Did he take something? Did he commit a theft? Yes, he did. Did he steal something of value? Yes, it was. I think, ladies and gentlemen, candidly, there's really no argument that what he stole was a motor vehicle. You've seen it. You've got lots of pictures of it. It's 2500 HD pickup truck. Clearly, he took that without permission. But what he did after that really is the heart of this crime. You see, even before pulling out the parking lot, he pulls down that mask, and we know that it is the face of Dexter Lawson. We know exactly who's taking it, and we know that that truck is working fine. We know that he's sitting there, and you guys can watch that video. You have to come back in here because I got to play it on the TV for you. But if you want to watch it over and over again, you can see him driving past the former airport right there beside the Oglotny River, working his way up into Havana towards Jameson Road, talking on the phone, drinking a drink, happy as you can be. Probably one of the more important things to notice is the way that he's conducting himself. He passes 100 cars going down 27, and not once does he swerve. Not once does he do anything aggressive. Not once does that car act out. He makes the decision to go down to Jameson Road, which is, as had come out, a dead-end road. He makes the decision to head down there and eventually turn around. The real victim in this case, of course, is not CH. It's a woman named Shakara Hearns. Shakara Hearns was sitting at a family member's house in Havana, grew up there, knew this area, had become a law enforcement officer a few years ago, went to Pat Thomas, and did her job well. She heard on dispatch that this theft had happened, and she went about doing what she's supposed to do. Let me get the truck back for those who have had it taken from them. She gets in her car. She's one of probably 2 or 3 deputies in the whole county, certainly the only one in Havana. She drives to Jameson and turns up an area she knows well. She knows the neighbors. She knows the neighborhood. She knows the fact that there's no access out that road. And then she comes up to this thing. You've heard the evidence. She calls out one more time, want to confirm this is the stolen truck. I've got it. Deputy DeLeon, remember he's on a detail. He hears, I've got it head to head. She does exactly what we are all taught when we learn how to drive. She turns on her red lights and she stops. That's when things change because he makes yet another decision. As you can see on the evidence that's on the screen, this is just literally seconds before the ramming. This is where we get into the attempted murder of a law enforcement officer. Ladies and gentlemen, the judge has told you that to prove the crime of attempted first-degree murder, the state must prove 3 things. 1, that Dexter Lawson did some act intended to cause the death of Shakara Hearns that went beyond just thinking or talking about it. Clearly, he went more than just, this was not just talk. This was not just thinking about it. This was an action. 2, Dexter Lawson acted with a premeditated design to kill.
Object. That's speculation.
Overruled.
3, the act would have resulted in the death of Shakara Hearns,
Object.
Overruled.
except that someone prevented Dexter Lawson from killing her, Shakara Hearns, or he failed to do so. That's where the meat of this is. And this is where I would like to focus most of my argument. We talked about jury selection that there's throughout life. Whether somebody does something on purpose or not, there is no magic FDLE. You saw a lot of FDLE experts that came in here, but there's no one. The only way you can tell somebody whether they're doing it on purpose or not is based on their actions before, during, and after. That's how you know what was going through his mind. And I would suggest to you that it's clear that he did something, some act intended to cause her, whether it was ramming her with a truck or filling her body with 9mm lead, he did an act. And that act, nobody stopped him. Bulletproof vest stopped him.
Object. He's leading the jury.
Overruled.
But for the grace of bulletproof vest and extraordinary medical care at Tallahassee Memorial, he would have been successful. The bullet stopped. 2 of them stopped at the surface of her vest. That's in that box. The one that got through ended up 3 inches from her heart after punching the lung. Now, there are 2 counts. The state would suggest to you that each of which are deadly weapons. They're the same crime, but let's look at what we're talking about. Would you rather be hit by a 1-ounce piece of lead or 4 tons of glass, steel, and rubber? Because that's what she had happen back to back.
Object. Speculation.
Overruled.
This is, you can look into the eyes of the man as he looks directly at the blue and red lights of Shakara Hearns' patrol vehicle. There's no question that he's being ordered to. And what did we learn from the accident reconstruction? He doesn't swerve to the right and go through the ditch. He doesn't swerve to the left to try to avoid her. He floors it and he power drives her straight down the road.
Object.
Basis.
Speculation.
Overruled.
The judge has already told you that even something that is not designed to be a weapon can be a weapon if it is used in such a way. Ladies and gentlemen of the jury, thousands of people are killed in this country by cars. Far more officers die.
Object. He misleading the witness, the jury.
Overruled.
Being hit by tons of steel in a motor vehicle than ever do by gunfire. He's looking at his victim and he's driving directly into her. Any argument if I was trying to go away is demonstrated by his behavior before, during, and after. He wasn't just trying to run into a tree or a car. No, sir. He was trying to. You can put your finger on this here so I'll keep it live. He was making the decision not to go here, not to go there, but to go right through there. I don't disagree. He was getting away, but he had stolen a car, and he made the decision that the way to get away with it was to kill the officer that was trying to stop him. And that's what takes us to count 2.
Object. Speculation.
Overruled.
Dexter Lawson did some act intended to cause the death of Shakar Hearns that went beyond just thinking or talking about it. 2, Dexter Lawson acted with a premeditated design to kill.
Object.
And 3,
Hold on.
Speculation.
Overruled. He's just reading out the jury instructions I've just instructed this jury on. Continue, Mr. Campbell.
the act would have resulted in the death of Shakar Hearns, except that someone prevented Dexter Lawson from killing Shakar Hearns, or he failed to do so. A premeditated design is to kill means that there was a conscious decision to kill. The decision must not be present in the mind at the time the act was, the decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The clear evidence here is, and if you want to look, this is before. This is during. But what we all know is that what happens next tells us what his real intention is. Because if it was to run away, he never turns back around. If it was to run away, we never see him coming back down that street. The truck didn't kill her. Let me get this gun out and finish her off.
Object. Speculation.
Overruled.
Shakar Hearns has been violently struck by the airbag. Troopers told us that that force is enough to literally tear arteries in her heart. Her deceleration goes from 0 to 24 in a second. Trying to get that button to open, trying to get out of that car, feeling the bullets hitting her back. Any suggestion of whether he was trying to kill her, I would suggest to you, is answered very clearly in the lethality of his aim. That's a great pattern. You trying to shoot a target, he put it on target.
Object. Speculation. He had no way of proving that.
Overruled.
6 rounds and he hits his target 3 times. He had made the decision to kill. He had made the decision to steal, and he made the decision to try to kill her with that truck. And when that didn't work, he decided to finish her off with that pistol. And then he committed his last crime as he ran away. He ran away, and what does he start doing? We see his outfit, and it's like breadcrumbs leading to him. Trooper Rittenhouse talks about the fact that I find a jacket here, find a shirt there, find this, find that, until he pops out of the woods. What does he do after? His behavior before is driving, having fun, I've got a truck, talking on the phone, drinking his Gatorade. During, he's confronted with a law enforcement officer. He doesn't run. He doesn't get out of the truck and run. He doesn't try to go around. He decides to go on offense and stop those who are doing their job. And even after he fails the first time, he comes to finish her off. And then after he's sitting in that patrol car, he's calm, and he's sitting there talking about whatever you all can hear. Whether or not there's cameras on whether he knows there's a camera that videoed him, whether they're going to find the gun, but he's clearly a person thinking about what's going on and not emotional, not worried about what he has just done. He has tried to conceal. To prove count 4, I have to prove that he knew that a criminal investigation was about to begun and that he did things tampering with vital evidence. Dexter Lawson knew that a trial, proceeding, or investigation that a duly constituted law enforcement or the state was pending or about to be instituted, and that he altered, destroyed, concealed, or removed any firearm or clothing.
IJ. Speculation.
Overruled.
Ladies and gentlemen of the jury, there's no other explanation except that knowledge of guilt. He clearly knew what he had done wrong, and that's why he did those things. The verdict form is complicated. The judge has gone through it well, but I would suggest to you what you need to do is recognize and follow this as you listen. As to count 1, is an attempted first-degree murder. Even if it was just a woman in a car, ramming her with that 8,000-pound vehicle and driving it down the road would have been a crime. It would have clearly been beyond just thinking about it or talking about it. It would have clearly been designed to bring about her death, and it would have clearly been an attempted murder. But once you find that, then there are 3 more questions. We call them interrogatories. We want to be very detailed. I would suggest to you that it's really beyond contestation that 1, Shakar Hearn was a law enforcement officer. You saw the vest she was wearing. You saw how she was dressed yesterday. There is no question. 2, that he knew she was a law enforcement officer. Once again, as you can see in the video, he's looking at the blue and white on. This is not an undercover case. This is not somebody in plain clothes. The purpose of sitting there and ramming is because he knows. And remember what that car looks like if you zoom out a little bit more. It says Marsh Young, Gadsden County Sheriff's Office. There's no question he knew her to be a law enforcement officer. And 3, CH was engaged in the lawful performance of a legal duty. Now, there's also all these lessers, and the best way I've always thought of lessers, if you've ever seen those Russian dolls that kind of stack on each other, that's how lesser included. You can't commit a first-degree murder without having committed a second. Can't get to a second. They all kind of stack on top of each other. So that's why there's a bunch of crimes here. I would suggest to you the evidence is compelling to the top, but let me explain. If he had just sat there and intentionally hit her with a car or a bullet, that would be an aggravated battery. That's where we start. Then you go, if you just hit her without a deadly weapon, that'd be a battery, an unwanted touching. So that's the lowest level. And then what makes it aggravated is the use of a weapon, a deadly weapon. Once again, whether it be the truck or the gun,
Objection. He's misleading with jury.
Overruled.
Whether the truck or the gun, that takes it to an aggravated battery, but it doesn't stop there. Then you have an attempted manslaughter. Manslaughter is just whether or not someone did an action that would have killed someone else, as it says in your instruction. If I do something intentionally, but I'm careless, if I'm negligent, we all have a duty to treat each other with the necessary caution. It required for manslaughter that Dexter Lawson intentionally committed an act that would have resulted in the death of CH, except that someone prevented Dexter Lawson from killing CH, or CH failed to do so. You see how that's part of it. If he had truly just slipped on the accelerator, if he had just been otherwise lawfully doing it and then lost control of his truck, that might have been a manslaughter. But it was more than that. It goes, which is where we go to second-degree murder. Second-degree murder is that Dexter Lawson intentionally committed an act which would have resulted in the death of CH, I should stop calling that, Shakara Hearns, except that someone prevented Dexter Lawson from killing Deputy Hearns, or he failed to do so. And two, the act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. I can see, there's no doubt, what he was doing there demonstrated a depraved mind without regard for human life. The question for you all, I would suggest, is, does it stop with just being a depraved mind? Because second degree doesn't require the state to even prove an intent to kill. There's a specific at the end of that. If he did these things, in order to convict of a defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to kill. But once again, he's just doing an act and accidentally, recklessly kills somebody, one. Two, second-degree, that's manslaughter. Go over to second-degree, I'm intentionally doing an act, and what I'm doing demonstrates a depraved mind without regard for human life. That's second-degree murder. But ladies and gentlemen, I would suggest to you, what we have here was not a depraved, well, it certainly was a depraved mind without regard for human life, but it was even more. The evidence shows through his behavior before, during, and afterwards that he had come to the point of making a decision. He made a decision on how to drive it. He did more than just talk or think about it. And he developed the premeditation to kill. Even if you should decide that there's any question as to whether he was trying to kill her with a truck, all of that, I would suggest to you, is washed away by his actions coming back down with that pistol. If you had any doubt,
Speculation.
Overruled.
if you had any doubt that he wanted her dead, you need only go back to the video. Once more into the breach. Ladies and gentlemen, that is the definition of premeditation.
Object. You can't even see that.
Overruled.
Ladies and gentlemen, the defendant has used his constitutional rights both for trial by jury and to represent himself, and the court has instructed you that you should give him justice. The state asks that through voir dire, I repeatedly asked, can you make sure that you're give the state a fair trial just the same as this defendant? Every one of you indicated under oath that you could and you would. His decisions on November 16th of last year clearly inform what your decision should be. Return a verdict of guilty as charged for each, not because you're angry at somebody, not because of prejudice, not because of what's happening anywhere else outside this courtroom, but because justice in this courtroom. Where we talked, if nowhere else in society, in this room, we will endeavor to make sure that there's justice for Prince and Papa, law enforcement and civilians. Justice is guilty as charged. Thank you.
All right. Mr. Lawson, you may argue.
The democracy is the people in power. If the people in power, that means that it's y'all decision. Okay? But y'all don't know law. So it's up to y'all at the end of the day. Okay? You gotta be able to presume I'm innocent and to prove I'm guilty. Okay? Prove that to me. They gotta be able to prove that beyond a reasonable doubt. They gotta say, I know for a fact that's me, right? Also, you gotta say, I know for a fact that I possessed the gun. Not just any gun now. You gotta be able to prove beyond a reasonable doubt that I possessed a Glock 45 that did what they trying to say that I did. They said earlier that it gonna show that I shot 6 times into a police car. First, you gotta tell that to me. First, then you gotta also really prove that I had a Glock 45. Okay, you got the deputy. She said that I run away and I turned right around and I ran toward her, and then I started shooting. Right, but yet I'm very describable. Like my beard, okay, my head, how I look, what I had on, okay, all that plays a factor in her to identify. So first you gotta identify who was shooting at you, because you can assume who's shooting at you, but how you gonna say I know for? She said she don't know for a fact I shot her. Okay, how you gonna be able to prove beyond a reasonable doubt that I had a Glock 45? Okay, can you play the random video?
Yes, sir, right here. From the beginning?
Yes, sir. Can you stop right now?
Sure, sorry.
Can you back up a little bit?
Sure. Tell me what
Right
you
now. All right, go back, come back.
forward.
Come back. Reverse. Not go forward, go back.
Okay.
Come back. Right now.
Right there.
All right.
Okay.
See how close that is? That's real close right there. You ain't gonna not go.
Just pull it. You want me to play it real speed?
It's on just play it.
Yes, sir.
She pulled in front of me. How you gonna be able to prove that I wasn't attempting to flee? How you gonna be able to prove that? I mean, she pulled in front of me. Okay, okay. The democracy is the people that are supposed to be in power. How could the people be in power if the people in power, that means the people is the superior when it comes to the government, because the government is supposed to work for the people, right? Okay. But how the government is set up is like they reversing it. Instead of them, we work for them. Instead of them work for us, we work for them, right? But how you gonna be able to prove beyond a reasonable doubt that I possessed a Glock 45 and I did that, and you ain't got no fingerprint, no DNA on the gun. You got this lady saying that she's seen a tall individual. I'm not tall at all. She said a tall individual with a tan uniform on, right? Okay, she never said, oh, he had on gloves. She never say, oh, he had a beard. She never say he had a big head. How you gonna miss that if you seen me shoot 4 times? You see me shoot 4 times, but at the same time, you ain't say nothing about no blood, but you know exactly what color I had on. If you know what color I got on, how you gonna miss the fact that I got on blood? How you gonna miss the fact that I got a beard? How you gonna miss the fact that I got a big head? That's very distinguishable. When they called the police, nobody could identify how I look. Okay, the other dude, when he testified, okay, he said I had on a checkered t-shirt, right? A checkered shirt. Okay. How many checkered shirts out there? I had on a tan jacket. Okay. Then you say, okay, first he say, I had on a blue shirt. Okay. Now you see me when I got on blue shirt, but you could have seen me when I had on blue shirt when I got in the police car. It's not mandatory that you seen me with a blue shirt on at that time, because for one, you missed the jacket. I got on a jacket. You said a checkered shirt. That could have been anybody. Okay, due to the fact that Debbie Hearn cannot say she know for a fact that I shot her, anybody could have shot her. Anybody could have did that. So if you gotta be able to presume that I'm innocent and to prove me guilty, how you gonna say I know for a fact that I possess the Glock, because the Glock 45? Can you show the window?
Sure. The window? Yes, sir.
How you gonna be able to prove I did that? It doesn't show that I did that. And then she said, okay, the thing about the situation right there, right? The state get all the evidence, they get everything, and and get what I get. I don't get nothing, right? But the state get all the evidence, and they talking with law enforcement and everything, so they can pick and choose what to present and what to leave out. That's an idiot. I know for a fact that a lot of the officers had a body cam and not even presented it that they had body cam, right? And if it's not in the state favor, they ain't gonna present that right there. They gonna edit. They gonna take some out. They gonna add this, and when you run it, it's like a movie. It's just like a movie. Even a movie look real. Okay, they say the smoke, right? Okay, but you manipulating the video. You was manipulating the video so much, it can look like I did something and didn't even do it. Okay, they said I was the only one on the scene, right? Prove I was the only one on the scene because nobody can identify how I look, and I'm very distinguishable. I got this beard. That's why I wanted to go ahead and go try, because I got this beard. Like, you can't tell me once you see me, you forgot how I look. You can't do that. You cannot say, oh, that's Dexter Antonio Lawson. You know Dexter Antonio Lawson when you see Dexter Antonio Lawson. So even the fact that you can say I was moving in a certain direction, okay, when you got this lady saying that it was a tall individual that shot 4 times. She said I shot 4, not 1, not 2, not 3, but 4 times. And you not knowing how I look. You said, okay, I don't got on no uniform. I got on a jacket. Okay. She never even said nothing about no glove. Debbie Hearn don't even say nothing about no glove. Nobody said nothing about no glove. Okay, how you see my shirt if I'm running away and I got on a jacket? Okay. The state out there, the country of this state will not allow anyone to be sanctioned on a conviction on speculation, intuition, or hunches. But yet it's full of intuition, yet it's full of hunches, yet it's full of speculation. Because how you gonna say I shot you, but at the same time you don't know for a fact, right? Okay. How you gonna miss the fact I got on gloves? You don't know who shot you, right? Okay. None of the witnesses identified me. I was identified solely on the camera, right? Okay, but yet the camera does not show nothing. I done seen a lot of situations that done transpired where they had more than enough evidence and never prosecuted that situation, period. So at the end of the day, how can you prove that I tried to? Okay, she pulled in front of me. Like she pulled in front of me. So therefore, How you gonna be able to prove that I tried to kill her? How you gonna be able to prove that I wasn't trying to flee? Okay, then you got a video of me saying anything in the bite seat, but at the same time, that has nothing to do with the evidence at hand. That has nothing to do with the act. Okay, first, not only they gotta be able to prove it beyond a reasonable doubt that I was on the scene, they also gotta be able to prove beyond a reasonable doubt that I committed a whole act. You gotta be able to prove that I committed a whole act. How you gonna be able to prove that I committed a whole act if it doesn't show what was shot? The country of this state would not allow anyone to be sanctioned on a conviction on speculation, intuition. They ain't asking y'all to speculate. They asking y'all to use y'all intuition and y'all hunches on something that they edited, like a movie. Like, this is, even movies look real. This is 2020. You can easily manipulate a video to the point where it'll come out looking just how you want to look at it. And you got all of them directing that round table. You got, okay, the law enforcement, they get all the evidence and they pick and choose what they want. Then they talk about it. But at the same time, put it on national news. Marsh Young, on national news, say Dexter Antonio Lawson did that beyond everybody. Prove that Dexter Antonio Lawson did that beyond everybody. Okay, direct evidence is proof. Okay, you got indirect evidence. Indirect evidence, which is speculation of evidence, right? But you got on national news, you say that I did that, right? Okay, now you gotta be able to prove that. Because at first, he said that. He said, oh, it's gonna show that Dexter Lawson jumped out, came back, and shot 6 times in a police car. It doesn't show that at all, right? Okay, and then how you gonna be able to prove the reason that I had a gun? Okay, hold on now. So, okay, this is not premeditated at all, right? Okay, when Deputy Hearn pulled in front of me, right, she put on the light, right? This is not a plan. This is just straight dumb. I mean, I'm off medication. You know what I mean? I'm like, okay, it's a trigger. I've been locked up a lot of times. You know what I mean? I've been through a lot of different things. So therefore, that's not a trigger. I got a million of ways that it could be a trigger, but yet I was told not to talk about Breonna Taylor and all the other stuff. You know what I mean? But okay, how you gonna? He said, I'm so happy. I'm drinking. I ain't nothing. Okay, but that has nothing to do with that. This not being premeditated. This is not being premeditated. This is a dumb situation that I put myself in. Like, how you gonna be able to prove that I tried to kill her and it was just something that happened? How you gonna be able to prove that I wasn't trying to flee? That's if you gotta be able to prove. If you gotta be like that thing about spade. You can make the rules, but you ain't no one can win from them rules. Like, you gotta be able to go. If they can't. This is their law. They law say that you gotta be able to prove beyond a reasonable doubt every element. Beyond a reasonable doubt every element, right? So you saying, okay, this is what I mean by that, right? Okay. The professional got out here yesterday, and she said, okay, the DNA could be destroyed when a bullet is fired, right? But what about the other bullets that was in the clip? Like, okay, so I understand. Okay, if you're saying the bullet that was fired, okay, that ain't got no evidence on it. They ain't got no DNA on it. But what about the rest of the bullets that was in the clip? Why? I know they did it. I know they dusted every single bullet, everything. They got a million pictures. Ain't no way around the fact that you can't connect me to that gun. If you can't connect me to that gun, and you got to presume that I'm innocent and to prove guilty because it done been too many times they done broke rules and bent rules and got away around the rules when it pertains to certain people. But I was told not to get into all of the different political things that is public information. Like, you say I got freedom of speech, but yet you tell me.
Sidebar.
Mr. Lawson, is there any reason that after this court tells you what you can't get into, that you turn around and tell them that you can't get into it, and then you start getting into it?
I got the freedom of speech to say. You told me not to get into detail about that particular thing. Only thing I was just making it known as in my defense, Judge. I mean, all due respect.
No, sir, I'm not going to let you talk about politics and people getting away, and I can't tell you about national events, but you know about national events. I'm not going to let you do it. You've done plenty of other good things. You've talked about the fact that they didn't look for DNA on the unfired rounds. You've talked about that the video doesn't show 6 shots. You've done a great job pointing out deficiencies. I'm just not letting you go down the political road of talking about national news events. The other stuff you're doing is perfectly valid argument, and you're doing just fine. If you stay with what talking about the facts of this case and what this state is not able to show, that is fine, and I'll let you keep doing that. But I'm not going to let you, especially when you acknowledged you weren't supposed to go into it, and then you went into it anyway. Okay?
Yes,
All right, step back. All right, Mr. Lawson, you may proceed, sir.
It's just the rules, right? The rules simply is plain and simple. Like, if you said I gotta be able to prove beyond reasonable doubt, if the state gotta be able to prove beyond reasonable doubt every element, not only do they gotta be able to prove that I was on the scene, they gotta also prove beyond reasonable doubt every element of a whole act. Okay. It's a lot of stuff that they just ain't even displaying. The only thing they is displaying is the thing that is not in my favor. Okay, but when you put all type of this, okay, how is it a crime for me to take off my clothes? This is not a crime for me to take off my clothes. Okay, prove I had that gun though. Prove I had that particular gun that shot 6 times when you got the deputy cannot say. She know for a fact that I did that. And then, if you know me, if you've seen me before, you'll never forget how I look. So, that right there, in the fact that you got all the witnesses. Okay, you got 4 different witnesses that was on the scene when that happened. Okay, I stayed in Jackson. So, you know how other people stay, a lot of people stay in Jackson. So when you say that, oh, I was on the scene, that's a lie because you got all kinds of people on the scene. And but at the same time, you don't know how I look. Like it's a video that I tried, cause they got body cam. They got body cam. A lot of them got body cam, but the thing is, it's not beneficial to let them know that, okay, we ain't gonna show it if it's not beneficial. If it's gonna favor him, we ain't gonna show it, right? But at the same time, nobody know how I look. How can you not know how can you say I'm running at you, then say you don't know how I look? You cannot. And then when Ms. Rodriguez got on the telephone, called 911, Ms. Marsh got on the phone and told him how many times that she got shot, but at the same time, you can't say that you can't say who shot you. I mean, and at the same time, you gotta be able to presume I'm innocent and to prove a guilty. All right, how you gonna be able to prove that and it doesn't show what y'all saying that it shows? You know what I mean? That's the crazy thought about the whole situation. It's like, okay, with the terrible evidence, okay, I took off my clothes. But at the same time, I stayed down the road. Like it makes no sense for me to stay down the road and did what I did. Like if I know for a fact that I did that, you know what I mean? So when the terrible evidence, it's not what evidence that I tamper with. Okay, I don't own that gun. Never seen the gun before. The gun is not mine. How you gonna be able to prove that the gun is mine? And if you know got the gun on me, you find the gun in the woods. Anybody could have had that gun. So how am I telling with evidence when the gun? I don't know nothing about no camera and no truck. You see what I'm saying? I don't know nobody no camera in the truck. I have no recollection of no camera in no truck. So therefore, it made no sense to me. And then the gun situation, right? Okay, they said evidence of value, fingerprints of value, but they ain't say the gun was completely clean. When they say they swore that gun and everything, okay, the gun was still the gun had DNA on it. The gun had DNA on it. It had fingerprints on it. So due to the fact that it didn't match with me, they saying, oh, y'all can't, by y'all finding them guilty on attempted murder, that automatically assumed that I had a Glock 45. Okay, but think like this. Look at it another way, right? Okay, they right, look at it like this, right? Okay, if the fingerprint was on it, if my fingerprint was on the gun, then that would have been proof. They would have been able to say they can prove aggravated battery if my fingerprint was on that gun. Due to the fact that ain't no fingerprints on the gun, and they saying that that's the only gun that was used, you trying to speculate, you using intuition and you using hunches to say, oh, even though the fingerprints ain't on the gun, Dexter Lawson still had a gun. But at the same time, how you gonna say this Lawson had a gun? You gotta at the same time prove, you gotta be able to presume that I'm innocent, right? Until they prove beyond a reasonable doubt that I'm guilty. That's an impossible burden if you can't prove that I had a gun. Like you, not only you okay, even if you say that's me or whatever, right? Okay, you saying that it shows that I shot 6 times into a police car. Like, you ain't asked Dexter Antonio Lawson who did it. No, you said Dexter Antonio Lawson did it. You went on national news and you said Dexter Antonio Lawson shot 6 rounds into a police car. Oh, and it's in the newspaper. This on Facebook. This on Instagram. This everywhere. So, and then you got a trial while I'm in Quincy. So, I mean, why are you doing all that if you got the proof? They don't even display the bullet. They don't even display the gun on the news. Like, they know because they ain't got no fingerprints on the gun. How you gonna be able to prove beyond a reasonable doubt that I had a gun and it's not my fingerprints on the gun? Okay? By you saying that I had on gloves, right? Okay. By you saying I had on gloves, that don't change the fact that my fingerprint on the gun, you can't prove premeditated murder, premeditated first degree attempted murder, right? You can't. Okay, this is not a plan. This is just something that transpired. I know nothing about a video. I don't know no camera in no truck. Okay, so it's like they don't got all the evidence. You paint a picture without proof. Then you saying that, okay, oh, even though he ain't got ain't no fingerprints on the gun, it's a possibility that he still had the gun. No, if I touch that gun, I'm grabbing that gun. If this is my gun, I'm grabbing that gun. I ain't got no gloves on while I'm grabbing the gun as mine. Okay, who would say the host of mine? You know what I mean? It just you can say what you want to say, but if you have no proof, cause it's 3 sides of the story. It's my side, your side, and the truth. Okay, and if you set the rules and you say, okay, you need proof. Beyond the proof is direct evidence. Proof is direct evidence. Proof is I know for a fact that he did that. Anything outside of proof is speculation, intuition, circumstantial evidence. That's anything outside of proof. And you say proof beyond a reasonable doubt. That means that more than proof. You know what I'm saying? Okay, you got less than proof. You got circumstantial evidence that, and you got to also prove that I was on the scene. Okay, yeah, I was on the scene, but you got to be able to prove beyond a reasonable doubt that I did what y'all said I did. And with the ramming, okay, how you gonna be able to prove that I wasn't trying to flee? How you gonna be able to prove beyond a reasonable doubt that I tried to kill her in the car? And that I can see that the truck and the car wasn't even that far apart. I ran my case.
All right, State.
Thank
You
you.
may present Rebuttal.
Yeah. No, I won't worry about it. I'm just like-
Mr. Lawson talks about a lot of things that the state doesn't have. I would ask you to focus what the state has brought. The state, certainly, if you look at the evidence in this case, any suggestion that Ms. Coggins wasn't being candid, I think you all had the opportunity to hear her. She became incredibly emotional on the stand. She explained to you that this was the scariest thing she had seen in her life and that she was still upset about it today. There was no question in her mind that the person that was shooting, she didn't even know was shooting at a deputy sheriff, that whoever it was, whether they were trying to kill a snake or a dog, that they were trying to kill them. That is direct evidence. The fact that Stephen Foxwell sees a man running in a red check shirt. He's a little further down the road. You recall he's the lawyer, retired lawyer, got a cane. How in the world does he know that there's anyone involved in anything? But he sees someone running through the neighborhood, first with a red shirt, and then now it's changed to a blue shirt. There was some conversation about, well, could it have been? Well, I guess it could have been two people, but I know beyond a reasonable doubt it was one person, and that person had a red shirt and a blue shirt. That's why we have trials where we organize. You met Amy George. We collect all the evidence. Sometimes it's relevant and sometimes it's not. Sometimes it supports and sometimes it's not. But ladies and gentlemen of the jury, here I would suggest to you, you have both direct and circumstantial evidence. You've got the video, which is extraordinary. Corporal Officer, I told you, I never get to see something like this. But you heard, and that's why we presented it to you, that he wasn't allowed to see the video until yesterday because he needed to make his conclusions based on the science of what happened with that truck. And that truck crashed into that car and drove it for 103 feet. He can show you the gouges in the asphalt. He can show you the debris trail. He can show you, and it was supported by the black box. That's another circumstance piece of evidence that shows that he was throttling the driver of that truck at 99%. It took a couple seconds, and then that truck was giving. Defendant continues to argue that, well, if I had been a little bit further, I would hit her a little harder. Ladies and gentlemen, I would agree. Thank goodness you weren't. You hit her hard enough. Defense argues that we should, for some reason, expect more of Deputy Harmon. That she had not done her duty that day, that she should have also been able to identify him as he shot her. I would suggest to you that Deputy Scar Hearns did exactly what we asked her to do each and every day as a law enforcement officer. In a moment, her life went from peace to battle. In a moment, she was hit by airbags exploding in her face and getting hit by 9mm rounds. Probably the most compelling thing about the character of that woman is when she did get into the Rodriguez's. Remember, as they came and tried to bring aid, she said, "Don't come out here." She knew the danger that was still making in the woods. The defendant argues that because I can't sit there and zoom in and show the colors of his creases of his face while he's pulling the trigger, the evidence does not.
Object. Misleading the jury.
Overruled.
Ladies and gentlemen of the jury, you have evidence clear and beyond any reasonable doubt that the man in the red shirt with the red gloves is sitting at defense table, that he stole that truck, that he drove it, and then he decided to run over that deputy. He's the same one that gets out and runs away. It's the exact same person. It doesn't make any sense. He asks you to force, imagine, speculate it down. it only is consistent because despite his argument, there were others who identified him. The people who pulled him out of the bushes as he ran through the woods. Let's not forget, at the end, despite getting rid of his jacket, despite getting rid of his gloves, despite casting the gun into the woods, despite getting rid of everything that he knew would hold him accountable for his choices, he still has that memorable face he talks about. And each of those officers said, that's the man who came out of the wood line. That's the man that my dog tracked from the driver's door of that truck through the woods on over a quarter mile, 0.35 mile, to the foot of Dexter Lawson. Dexter Lawson made some choices on November 16th. Thank goodness he failed. Thank goodness but it doesn't mean that you should. Justice must be had. His decisions to ram her, his decision to try to bring an end to her life, his decisions to start shooting. You could see the 6 bullet holes in that car. Now, I've been a lot of evidence, and I kind of want to give you a little bit. A lot of this we never opened in package. We used pictures. You all, it's in evidence, so you guys could actually dig into it, but there's some glove issues. So the pictures are going to go back with you. The foam boards are going to go back with you. But we can't send a computer back because, like the judge says, you can't go and do Googles on this stuff. So as you are doing back, if you'll write a note, we can let you come in and we can open. You want to see the bullets in her vest? We can show it to you. If you want to sit there and open every glove, we can open it for you. But at the end of the day, ladies and gentlemen, I'm confident that you all have seen the truth. That's what verdict stands for. It's Latin. Veris dictum, speak the truth. The truth is that Dexter Lawson is guilty of trying to kill Shakara Hearns with his truck. Not his truck, it was the McNeil truck he had stolen. He's guilty of trying to kill her dead by shooting her with a pistol. The same pistol that's forensically proven to be the shell casings outside. The same pistol that's cast into the woods along the trail he ran. And that as he cast that gun,
you haven't proved, you speculating.
Overruled.
He's guilty of tampering with the evidence that proves his crime restraint. Come back with your heads held high, knowing that you've done justice. Come back with a verdict of guilty as charged. Thank you.
Now, in just a few moments, you will be taken to the jury room by the bailiff. Okay. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Now, I'll go off script here. Normally, I've allowed you to have your cell phones and things like that with you during the breaks. When you go back to deliberate, the deputy will take custody of those and safeguard them for you. So you can't have cell phones, or even if you have an Apple Watch, any smart watches, anything like that, you'll need to turn them over to the deputy, and the deputy will safeguard them for you during your deliberations. Now, if you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the parties before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. Now, during the trial, items were received into evidence as exhibits. During your deliberations, you may examine whatever exhibits you think will help you in your deliberations. Some of these exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any other admitted exhibits, please request that in writing. So I'm not sending the gun back there with you. I'm not sending the videos back there with you. I'm not sending back any of these things with the evidence tape on them. If you want to see them, you can write a note and let us know what you would like to see. Please be specific. But all those pictures will go back with you. Those admitted boards with diagrams, those will all go back there with you. If you need to see anything else that was admitted into evidence, just write a note and we can do that for you. Now, in closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Now, you may also take any notes that you took during this trial back to the deliberation room. As previously instructed, your notes are a tool to aid your memory. Notes are for the note taker's personal use in refreshing his or her recollection of the evidence. They are not evidence. Above all, your memory should be your greatest asset in your recollection of the evidence. Now, at this time, jurors number 7 and 8, Ms. Pruitt and Ms. Wolf, you are our alternates, and so you will be discharged from this jury panel at this time. Now, do you have any items back in the jury deliberation room? Yeah. All right, that's what I figured. So what will happen in a moment when I have the jury go back into the room, you'll just stay outside the room. The deputy will go in and get your stuff, bring it back to you, and the deputies will get you where you need to be. Now, if you want to stay in the courthouse and you want to stay here and await your fellow jurors to return a verdict, you can do that. This is a public trial. If you would like to, you can call tomorrow or the next day. You can call the clerk's office and they'll let you know what happened, as this is a public trial. I do, again, thank all of the jurors for serving on this jury. For those 2 of you, obviously, you have now served your jury duty, and so you are excused from state jury service for 1 calendar year. Again, I can't do anything about that federal jury service if you get a summons. But if you get a state summons to have you report within the year, just contact the clerk's office. They'll take care of you. And so with that, the only final thing is I'm going to send back the verdict form with you now. In a moment, the parties are going to, when you guys go on and back there, the parties are going to meet up. We're going to make sure you've got the evidence you need to go back there, and either one of the deputies or the clerk will bring back the items you can have back there with you, and they'll bring those back in a moment. So with that, at this time, the jury may retire to deliberate.
All rise for the jury.
Yeah, I just think that you can't lose, you know, it is.
All right, the jury is departed the courtroom. Everyone may be seated. Are there any objections to the jury instructions as read?
No, sir. That's our agreement.
Mr. Lawson? All right. In a moment when we take a break, I'll have the parties review the evidence. The court, I like to do this. It's my normal habit. I have admitted into evidence states 1, states 2, states 3, A through L, States 4A through W, with the exception of states 4R, 4U, and 4V. Those are not admitted. I have states 5A through I, states 6A through E, states 7 through 19, states 21 through 25, states 27 and 28, states 30, and states 31A through G. So again, the intent is the intent will be the pictures and the foam boards can go back. Everything else will stay here.
Your Honor, I think there may be two more. I added last minute after I typed on stage 3A through N November. There's,
That's right. Well, hold on. Let me check. I think that may be right. I think I might. Yeah, and I've got that in my notes. Thank you. That's why I do this. I want to make sure the record is very, very clear. That's why I always do this.
and to be clear, stage 20, which is a black fabric mask, I did not decide to introduce. 26, which was the victim's uniform that I had on my pre-mark. I decided to use photographs instead of doing that. So I did not introduce or try to, that never came from the jury. Stage 29, which was some sketches by the accent reconstructionist. I just used the foam board instead of some smaller sketches. So that's, those were not ever mentioned to the jury, nor were they attempted to be introduced.
Understood. And that's, yeah, I never saw those states ID, those exhibits for ID either. All right. The only final matter I have is, and please be seated, is the court will note during a couple of times during this trial, particularly even yesterday, the defendant had noted some mental health history, some medication. The court will note that before this trial, there was a competency evaluation ordered, competency hearing. The defendant was found competent. The court will note for any review authorities that over the past several days, the court has spent numerous hours in the presence of the defendant and counsel for the state in the conduct of this trial. During that time, Mr. Lawson has behaved appropriately. He's been respectful to the court. He's been respectful to opposing counsel. He has asked thoughtful and intelligent questions. He's adapted based on the answers to those questions. Whereas he may have disagreed with some legal rulings with this court, he has shown an understanding of those rulings. He has shown that he has the ability to comprehend the occurrences of this court, and accordingly, this court finds and found no reason at all during the course of this trial in any way, shape, or form to question his competency to stand trial. So I want to make sure any reviewing authority doesn't question that this court should have ordered a competency evaluation mid-trial, that the defendant showed that he was in full command of his faculties and his understanding and his ability to proceed. Now, the wisdom with which he used on representing himself, I guess we will find out upon the conclusion of the jury's deliberation, but he was of sound mind in making that decision and fully aware of the consequences of that. So with that, we'll close for deliberations. And, don't anybody go too far, and we'll see what the jury's got for us. Anything else we need to discuss?
No, sir.
All right, the court will be in recess.
I hope I have some sound. I'm not sure I do because I did disconnect the microphone. I have been editing all day, working on the Charles Adelson trial. Doing the jury selection has been very, very time consuming, but that's coming your way very soon. This weekend, Sunday, when you're actually going to get to hear Georgia Kappelman and Joshua Dubin talking to the jurors, asking questions, etc., etc. I'm debating a little bit about whether to increase the volume when the jurors speak, and I think I'm just going to leave it low volume. I think that what matters really is what the attorneys are asking, what they're saying. So I'm also going to try to protect the privacy of the jurors. But I hope you guys enjoyed so far what we shared on this trial. It's got a lot of crazy moments in it. And Ladybug will resume on this trial next week on Monday. Okay, guys? Very nice to see everybody. Thanks for watching Mentor Lawyer. And yes, I do have some tennis coming up today. All right, have a good one. Bye-bye.